Alors, je suis très heureux de vous voir en si grand nombre pour la 3e édition du symposium. Comme le veut la tradition, la date choisie pour l'événement tombe à nouveau dans le cadre d'une belle journée du mois de février. The symposium is once again the result of an intense collaboration among several entities located in Montreal, sharing an interest in international arbitration. The conference is sponsored by the McGill Journal of Dispute Resolution, of which I'm the editor-in-chief, the McGill Arbitration Student Society, BLG, which has graciously accepted to host this event, and the Private Justice and the Rule of Law Research Group. I would like to thank all the people who worked very hard to bring this event together. In particular, I'd like to thank Sunny Yang. He's somewhere in, no, okay, he's not here. He's the managing editor of the MJDR. I also like to thank Maître Jacques Darche et Maître Christina Burks, Madame Van Buy, qui n'est plus là, as well as Petra Vetrova, president of the McGill Arbitration Student Society. Permettez-moi maintenant de vous présenter Andrea Björkland, qui a gentiment accepté de modérer la conférence. Elle est professeure à temps plein à la faculté de droit de l'Université McGill et titulaire de la chaire Yves Fortier en arbitrage international. Diplômée de la faculté de droit de Yale, prior to entering academia, she worked on the NAFTA arbitration team in the U.S. Department of the State's Office of the Legal Advisor and worked for Commissioner Thelma Askey on the U.S. International Trade Commission. Professor Björklund will now briefly introduce the speakers and the topic of the conference. Merci de votre attention.
Merci, Giacomo, and thank you all. It's very nice to see a full room for this event, and I'm really honored to introduce to you our speakers. We have an all-star lineup, including people who have come from halfway around the world to be here, and it's a great pleasure to welcome them to Montreal. So I will introduce the speakers in the order in which they're going to talk to you, and after each has given his or her presentation, they would be happy to take questions. So first, we have the pleasure of hearing from Stephen Drymer. Stephen, as I think most of you know, is a graduate of the McGill University Faculty of Law, and he's a partner here at Woods in Montreal, where he leads the international arbitration practice. He has acted as both counsel, and he frequently sits as arbitrator in both commercial and investment treaty disputes. And then our final speaker is also a graduate of McGill. Margaret Ryan went to law school at McGill, has an MPhil in European philosophy from Cambridge, and a BA in contemporary philosophy from Dalhousie. So Margaret is an associate in Sherman and Sterling's London office, where she specializes in international arbitration and has in fact worked on arbitrations with a variety of institutions, has worked in ad hoc arbitrations, and has a focus on energy disputes and matters involving clients with interests in Africa. So Steve is going to start us off with a presentation about the IBA rules on the taking of evidence and with some specific focus on document production and related matters, including those touching on privilege. Anna will follow to talk about the preparation of and presentation of expert evidence, and then Margaret will discuss the role of fact witnesses and best practices for the preparation of fact witness statements. So I'm delighted to see you all here, and I look forward to hearing from them. So I'll turn things over to Stephen now.
Thank you, Andrea. Thank you to the Journal, Giacomo, to the McGill Association of Arbitration Student Society. I hope you're here en masse. It's a pleasure to be here. I did not come from halfway around the world, but I am no less pleased and honored to have been asked to address you. As Andrea said, this conference is dedicated to the topic of evidence in international arbitration. I've been asked to speak briefly about the IBA rules on the taking of evidence in international arbitration generally. I will not step on the topics that my colleagues are going to be addressing, but I'm also going to address one particular facet of those rules, which have to do with production of documents and, as Andrea said, ancillary questions such as admissibility and privilege. I'd be remiss if I didn't thank my colleague at Woods, Laurence Sainte-Marie, for her help in preparing some notes for this conference. Laurence has just joined us after a couple of years at de Reims-Garavie in Paris, and she, as many of you in this room, is already quite experienced in this field. So let me just apologize in advance. I'm looking over the room and I see it's quite a diverse crowd, from students to practitioners. I'm sure many of you are well aware of much of what I have to say. Some of you perhaps less so. And so I'm sorry if I'm either speaking over your heads or below your level of knowledge. It's hard to know exactly how to pitch these things. But I do encourage you, as Andrea said, to ask questions or to seek clarification or to offer comments as we go ahead. So a bit about these things called the IBA rules on the taking of evidence in international arbitration. A very quick who, what, why, when, and how. I'll begin with the why, if I may. Beginning in particular in the second half of the 1990s, I think the perception became especially acute that there existed a vacuum and a corresponding need for guidance with respect to the evidentiary practices in international arbitration. As you know, or as you may know, rules of court generally do not apply in international arbitration. I'm talking rules of practice, unless the parties expressly agree, which is usually not the case where parties hail from different jurisdictions. Arbitration rules, for example, institutional rules of the International Chamber of Commerce or the LCIA or the AAA or Canadian sets of rules, only provide, for the most part, a skeleton of procedural steps involved in an arbitration, leaving the parties to develop the rules in conjunction with the tribunal. They typically provide for the largest possible discretion to tribunals and parties to set the rules. So there was a perceived need for guidance, if you will, in this unusual arena of arbitration or adjudication in an intrinsically international context. And what do I mean by that? International arbitration, well, those of you who attended the Brierley lecture at McGill about 5 years ago would have heard Jan Paulsen, one of the greats in this world, tell us why international arbitration is not arbitration. And by that he meant that it's a beast entirely separate from what each of us, in whatever jurisdiction we come from, would know as arbitration in her or his domestic context. International arbitration is, in fact, divorced from, to a large extent, not exclusive, not wholly, obviously, national rules of practice, unless they're specified. It is intrinsically something very different than what we know in any given jurisdiction, either before the courts or before arbitral tribunals that might be set up. It's been called transnational in nature, or even anational in nature. And what this means is that in practice, arbitrators look for approaches, and parties look for approaches that are neither fish nor fowl, neither a common law tradition necessarily, nor a civil law tradition necessarily. And I can tell you, I've learned this, that common law and civil law are not monoliths either. The practice before the courts in France differ enormously from the practice before the courts in Quebec, notwithstanding that we're both civil law jurisdictions. And the same, of course, holds true within common law jurisdictions. Suffice it to say that the view that there was some need for guidance, a degree of harmonization, a leveling of the playing field so that people would understand what they were dealing with coming into the process of international arbitration became especially acute in the 1990s. And in 1999, the International Bar Association, which is essentially an association comprised of national bar associations and lawyers from those national bar associations, took upon itself the mission to try and develop rules on one particular aspect of the procedure in international arbitration, and that has to do with the taking or the gathering of evidence. Now, who prepared these rules? This was a working party of something called the IBA Arbitration Committee, which, for what it's worth, happens to be the largest committee in terms of membership of the IBA, composed of, we're told, over 2,500 arbitration practitioners from over 90 countries. It's a very representative group, and I've told you that the IBA itself has a mission and is composed in its membership of lawyers from over 100 countries, we're told. Now, the IBA rules are not substantive rules of evidence. They say nothing about hearsay or probative value or litigants' rights under statutory rules or case law that grant access to certain documents. They rather relate to the process for the taking or gathering of evidence and the presentation of evidence in the context of an international arbitration. They aim to assist in organizing the evidentiary process. Again, I can tell you from experience that in an international context, that alone was a heavy lift, if you will, to try and come up with rules or guidelines or a process that would speak to and satisfy the interests and the needs of parties, first and foremost, and lawyers and arbitrators hailing from jurisdictions around the world. The rules are meant essentially to fill gaps. That's my word. But these are not my words. I quote, "They're designed to be used in conjunction with institutional, ad hoc, or other rules or procedures governing international arbitration, and they reflect," quote, "procedures used in many different legal systems." That's what they're meant to do, and again, that's what they do. You won't find your rules of practice or your rules of evidence in here. What you'll find is elements of what you may know in Quebec, in Ontario, in New York, in Paris, in Dubai. Let me tell you a bit about how they come to apply in a given case. As with almost anything in arbitration, again, I'm sure most of you know this, everything begins with consent. Arbitration is a consensual process, but for the very fundamental precepts of equality and fairness, most laws, most rules don't say much in terms of how an arbitration is meant to be conducted. Institutional rules, I mentioned ICC rules or other booklets of rules provided by arbitral institutions or administering institutions, tell you something about how an arbitration is to be conducted in accordance with their particular rules. But there too, those of you who've seen those rules or used them will know that there are a lot of gaps to be filled. And so the use of these things called the IBA rules on the taking of evidence in international arbitration arise typically following the constitution of a tribunal, typically at an organizational meeting, a first meeting between the tribunal and the parties. Typically, either the parties will propose or increasingly tribunals or arbitrators themselves will propose the use of these rules. Now, again, excuse me if all of you know this, they're called rules, but they are rarely adopted as binding rules. They're most typically adopted by parties and tribunals as quote-unquote guidelines or rules to which the tribunal and the parties may refer, the tribunal in its discretion, and we jealously guard our discretion, rules to which the tribunal may refer to guide the parties in respect of various aspects of the taking of evidence. And again, I'm using this term of art, taking of evidence, but just to give it some flavor in case there's any uncertainty, this involves everything from dealing with documents, to dealing with witnesses, to dealing with experts, to certain aspects of the conduct of the hearing. How does a tribunal take cognizance? How does an arbitrator or an adjudicator take cognizance of evidence? And these rules cover, I won't say all aspects, but many aspects of that process. I'm conscious of the time. Let me skip. I have time. Well, all right. Thank you.
How many times does a moderator ever say that?
No, that's good. I said I'm conscious. I didn't say I'm running away. I should tell you that the rules are also increasingly used, referred to, even relied on by national courts around the world, in Canada and elsewhere, in various jurisdictions, where issues having to do with the conduct of the arbitration arise. I'm not going to talk about enforcement of arbitration awards. I'm not going to talk about homologation. But suffice it to say that in those rare instances where courts are called upon to address issues that go to the conduct of the arbitration, these rules, non-binding as they may be, aspirational as they may be, are increasingly relied on as, if nothing else, than a statement of best practices vetted by and used by large numbers of people practicing international arbitration. And in my view, they effectively glean their authority from the fact that they are used, not because they've just been promulgated, but because they're used. Some of you may have heard of an annual survey of international arbitration practice. White & Case, a US-based international law firm, and Queen Mary, University of London, have published an annual survey of international arbitration for the last 6-7 years or so. And they survey users, but most importantly, they survey me, and they probably survey those of you in the room. Most importantly, they reach out to and survey companies, actual users, the parties, the clients, the people who pay the bills in international arbitration. And consistently, and frankly, this accords with my own experience, and I would venture to say those of others in the room. The IBA rules are, quote, the most widely known, the most frequently used, and the most highly rated of the many, and I stress many, international arbitration guidelines and principles that are out there. And this despite the fact, also revealed annually in the White & Case Queen Mary University survey, again, it's a sentiment that I happen to share myself, that international arbitration is already sufficiently, if not to say excessively, regulated by a host of competing soft law principles, rules, and guidelines. The IBA is just one organization that purports to tell you, to tell us, to suggest how arbitration should be conducted, what principles ought to apply, whether it's with respect to taking of evidence or ethics or counsel conduct. There is a lot of literature out there. If we're talking about these today, if the organizers have asked us to speak about these today, I think it speaks of the fact, again, that they are used by lawyers, by arbitrators, by parties, by judges. Let me talk briefly about the fundamental principles as laid out in the IBA rules, and some of the changes that occurred in 2010 when the original version of these rules was revised and updated. First of all, flexibility. Those of you who know anything about arbitration, and I'm sure that's everybody in the room, and this is as true domestically as internationally, flexibility is key. Arbitration promises nothing to parties if it doesn't promise the ability to do something differently than is done before the courts. And the rules expressly state that they are not to be construed as limiting, and I quote, the flexibility inherent to international arbitration. My view is that's inherent in, or should be inherent in domestic arbitration as well. The second fundamental principle for which these rules stand is the duty to act in good faith. Now, in the parties' duties and lawyers' duties to act in good faith in carrying out the procedural steps that are articulated in these rules. Now, that was a bit of a revolution. Those of you who are common lawyers as opposed to civil lawyers might say, what the heck is good faith? It does not exist in many common law jurisdictions. It's not an inherent contractual principle. It was imported into these rules in 2010. The third fundamental principle, and this will come as no surprise, I think, is the right of each party to know in advance of any hearing or any determination on the merits of any issue before a tribunal, the evidence on which the other parties rely. No ambush. Again, that will be familiar to anybody who's practiced before a court of law in any jurisdiction. Everybody says no ambush, but the Americans don't ambush you in ways very different than the English don't ambush you, or the French don't ambush you, or Quebecers or Ontarians don't ambush you. All of which in the service of fairness and efficiency both in terms of procedural economy and financial economy. There is a recognition that arbitration, particularly international arbitration, for all that it may have going for it, that's a different conversation, is no longer as cheap or inexpensive as it was once perceived to be. There is a perception that that cost effectiveness as well as procedural economy was an issue. And again, these rules, I'm calling them rules, that's what they call themselves, are meant to advance the cause of, as I say, both procedural and financial economy. Let me move now to the question of document production. All right. As I say, the IBA rules represent international best practices as articulated by a representative portion of the international community, which means, of course, those who participated in the process, right? That's democracy. Those who are able to participate in the process, that's democracy too. My colleagues are going to be addressing issues related to expert evidence, witness evidence. I'm going to speak to you about document production. Now, I'm particularly happy to do so because, again, I think it's fair to say that those of you who have used the rules, those of you who practice in international arbitration will have a sense that if there's one aspect of these rules which is most frequently cited, most frequently relied on, whether as a rule, whether as a guideline, it is the rules having to do with document production, discovery. All right, what can you ask for from other parties? What are the principles and the standards according to which documents can be requested from another party and according to which tribunals will order document production? So these are found in Article 3 of the IBA rules, which begins with the very non-controversial, I would suggest, principle that each party must introduce those documents available to it and on which it relies as evidence, all right, which I say should not come as a surprise because it reflects principles accepted in both common law and civil law traditions writ large. Parties have a burden to prove their case. Parties have a burden to put forward the documents on which they rely. Now, that's where the common ground between many common law and civil law jurisdictions ends. And that's why, in respect of document production, there was a need perceived, and I think, in fact, to try and standardize practices to an extent, so as to make sure that a New York lawyer who's under a professional obligation to produce all documents relevant to the case, and a French lawyer who's under no such obligation whatsoever to do anything other than to produce the documents on which she or he relies in support of his or her own allegations, except as ordered by a judge. It was understood that there was a need to allow these two traditions to interact fairly. And so I'll tell you very quickly about how these rules work in practice. Believe it or not, before 2010, there were rules on the production of documents, but they didn't include some of these, what by now have become fairly standard and I would say obvious approaches to the issue. I mentioned that in civil law countries, parties are only, well, again, not civil law, in certain civil law countries, parties are only required to produce the documents on which they rely and not required to disclose anything else whatsoever. But as well, and this is a feature of civil law practice which Quebec civil law practitioners won't recognize because it doesn't exist in our civil law jurisdiction. It's in other civil law jurisdictions, it's the courts that regulate, assess, and effectively initiate evidentiary proceedings. Right? It's judges who will often say, you must produce this document. It's not the parties themselves organizing the procedure. There's no real motions practice, as our American cousins refer to it. Whereas in common law jurisdictions, Anglo-American, Canadian common law jurisdictions, Quebec, of course, is this very interesting mix. The evidence is typically organized in a pretrial phase, mostly carried out by the parties themselves, who make requests to each other for the production of documents relevant to each other's cases. I will ask you for documents in your possession that may be relevant to my case. The rules aim, the IBA rules aim to effect a balance, in effect, on the basis of the understanding that some level of document production is necessary, but that certain of the excesses, what were perceived as the excesses of, let's just call it American. I don't like when people talk about the Americanization of arbitration, but as a caricature, it's not a bad one. All right? Some of the excesses of U.S.-style discovery could be avoided in the international practice. And so the rules set in motion, if they're followed, and they're typically followed in international arbitration, the following sort of practice. The parties are allowed to ask each other for documents which are, and this is interesting, in these rules at least, relevant to the issues and material to the outcome of the case. Now that's a very interesting test. It's not just a relevancy test, it's a material test, though those of you who've read the rules in French will not find the word material in there, so that's a debate that I've had to deal with before a couple of tribunals. But I just note that parties are allowed to make certain requests, but that the standard is typically pretty high. They can make requests for relevant and material documents that are known to exist and are known to be in the possession of the other party, or for a reasonably specific category of documents. The idea, of course, is to rule out the partie de pêche, the fishing expedition, which is not unique to U.S.-style litigation. Anybody who's been in a court knows. And so already the idea is to restrict the ambit of documents which are able to be sought from the other parties. The idea being that this restricted ambit of documents is really all that's necessary in order for an arbitration to be conducted and for a fair and just decision to be rendered by a tribunal. All right? Put out of your minds that every document in existence is considered necessary in international arbitration. It isn't. All right? You get up before a French judge, arbitrator, a German judge, even a Canadian arbitrator now. I mean, I've had to learn, and my practice before the courts has evolved accordingly. Much of what's produced, much of the paper that's produced, is wholly irrelevant, maybe not to your allegations, but wholly irrelevant to the way the case is going to be decided down the road. Many jurisdictions understand this a lot better than our own here in Canada or in North America, I'd say. Many jurisdictions in court, never mind in this funny thing called international arbitration, get to excellent decisions without the voluminous materials that even our courts have beside them and behind them when a case is decided. That's an important principle. I'm not sure whether my friends are going to talk about this in terms of witness evidence, but my guess is they will, at least I hope they will. The idea that in an international arbitration, one simply does not have the virtually unlimited scope that one has before the courts, at least in a North American or a British setting, to gather not just documents, but any evidence that one feels is necessary. Unlimited witnesses, unlimited questions to the witnesses, experts. Those of you who are Quebec practitioners and have studied the provisions of our new Code of Civil Procedure, I digress for 30 seconds, will note that will note that this idea, you may not know where it came from, but the idea that parties no longer have a complete control over the extent of evidence produced before the courts is now more and more ingrained in our code. You can't produce as many experts as you want anymore. You can only engage your own expert with the permission of the court. It seems odd, it seems screwy, it's going to take a long time for us to get used to it, but let me tell you, it works perfectly well in most of the world. International arbitration, I've learned, and it's affected my litigation practice and my domestic practice, international arbitration is informed by the fact that there are other ways, I would say, quicker, less extensive ways of gathering evidence that still allow decision makers to get to the truth and to get to the issues that need to be determined in order to adjudicate a party's dispute. So, back to the practice. Parties make requests for documents of each other. Each side either produces the documents or objects. Objections that can't be worked out between the parties only at that point go to the tribunal. They go to the tribunal in the form of something called a Redfern schedule. I'll spare you that, but they come to a tribunal. The tribunal decides objections all at once, and then production takes place. But again, in considering discovery issues, document production issues, as and when they're brought to my attention as an arbitrator, if we've agreed at our first organizational conference that the rules will either include these rules or that the IBA rules will be referred to as guidelines, we will be inspired by these rules. And I'll say more. Unless explicitly excluded, which I've never seen happen and I suggest will never happen, the IBA rules have become effectively soft law. If you say nothing to an arbitration tribunal, an international tribunal, about the basis on which they should decide how many documents are required or what contortions a party has to go through to satisfy the requests of the other party, tribunals will be inspired by these rules, all right, because they happen to reflect increasingly common international practice. I don't really have time at the moment, unfortunately, to address issues of admissibility and privilege, but I'll leave you with this thought. I'm not here, and whenever I speak to clients or colleagues about international arbitration, I'm not here to tell you it's the greatest thing since sliced bread. There are very good reasons to use international arbitration in certain contexts, but there are also gaps. There are also issues that cannot be resolved so simply, including privilege. Right? When privilege issues arise in international arbitration, unless the parties and the tribunal have had the foresight, which is almost never the case, right? And I counsel clients in drafting clauses as well as plead cases and arbitrate cases. Unless the parties have had the foresight to say very clearly, privilege issues will be addressed according to the laws or rules of a certain jurisdiction, it's not always so obvious where an international tribunal looks in terms of inspiration for deciding issues of privilege. The IBA rules say this, and they say only this, that parties may refuse to produce documents, or tribunals may refuse to order the production of documents or other evidence by virtue of, quote, legal impediment or privilege under the legal or ethical rules determined by the tribunal to be applicable. All right? That leads you to a very important conflict of laws type assessment of what rules apply. There are different ways to get to the answers. I won't take you there. Suffice it to say that, again, international arbitration is not a panacea. These rules aren't meant to replace, as I said earlier, substantive rules of evidence or or privilege in this case, but they are meant to offer guidelines and at least to show you, to show parties, to show lawyers and tribunals where to look for, how to get to certain answers. And in terms of the actual organization of an arbitration, I've been doing this for almost exclusively for about 15 years now, and I can tell you that these have made a big difference. They might be wrong, they might be right, they might be perfect or not. There's no such thing as perfection. But they are enormously helpful. Anything that allows practitioners, parties, arbitrators from different jurisdictions to operate in a process that is understood by all and gives all an equal opportunity to make their case is, in my view, to be applauded. Et voilà, thank you very much, and I look forward to discussing with you any questions you might have, either now or later on. I'm in Andrea's hands.
Thank you very much, Stephen. Why don't we go ahead and hear from our other speakers and then take
Perfect.
questions, collect questions at the end. So if you have questions for Stephen, please collect them and we can ask them later. So thank you, Stephen.